the slides now.
So we're going to be talking about options. We're going to talk about labor certification versus national interest waiver. Many of you have heard about that, but haven't really gotten much information about it. For some physicians, both might be good options. For many physicians, maybe one. Extraordinary ability, in the extraordinary ability, we have been asked lately a lot by our clients because it seemed until not long ago it was the best option. Now it's not so good.
Right, we'll discuss how that landscape's changed a little bit.
And then we'll talk about priority dates. I think this is key to understand the immigration options and questions and answers. So let me start with this, because we always like, when we talk about physicians, immigration or not immigration, temporary cards, we like to start with this slide because it gives you a good idea of where you start. The yellow is what the different steps or different stages in a physician immigration life, let's put it that way. So you start with medical school, whether in the United States or outside the United States, and when we say in the United States, we're talking training programs, residencies or fellowships. Then, and depending on the status, it might be a J1 or not. You might do your residency or fellowship program. And then, depending on whether you do your training program in H1B or J1, then there are different options. Regardless of the options, you might, after the residency program and after you're able to navigate that process, then you want to obtain a temporary visa in the United States, and from there, obviously, the permanent residency and finally the citizenship. So you can see, yes, there's a lot of arrows pointing different directions because that's how it is. It is very clear and easy to navigate.
And complicated.
That brings us to, okay, my slide. Start now moving. Okay. So the options, we have different options. Those are the main options, or actually the only options is labor certification, national interest, extraordinary ability, and the extraordinary ability, it is just straightforward extraordinary ability or professors and researchers, and those are, for purposes of this conversation, we are going to briefly talk about professors and researchers, because that's a very specific area.
Yes.
Very few meet that one. Other options is family asylum and the lottery. What is the process? So let's start with the labor certification.
Labor certification. So we often present this to clients as a very viable option, especially our foreign physicians. The perm labor certification is you'll see that there's 3 steps identified. First, we'll go through labor certification. After you have the labor certification is when you can file your immigrant petition with immigration with USCIS. And after that, once the priority date becomes current, is when you can proceed to actually obtain your green card or the immigrant visa. And depending on where you are in the process, whether you do it here internally with USCIS, you file the I-485, or if you do it through the U.S. consulate, it's the DS-260. So labor certification, there's several things that you need to keep in mind. If the employee's ownership status in the sponsoring company, if that is a key component, we need to discuss it. For example, if they're a shareholder, partner, member, and we see this a lot with physicians who form their physician group clinics. And so that is something that has to be disclosed on the perm application and can have other implications. We won't go into a lot of detail of it, but just know that if this is in fact an issue, it needs to be addressed, and we'll have to discuss it further in detail with you about how that's addressed and how maybe we'll have to look at restructuring things so that way the perm can proceed. Another thing that will have to be disclosed, and this is specific on the perm application, is if there's employees that have family relationships to the owners or the sponsoring company. Again, a lot of foreign physicians, people that come over, will look into doing business with family, and that is not unheard of, but it is an added factor and an added issue that we need to address if we're discussing perm, and that is the situation. With physicians also, we have a lot of roaming physicians, a lot of physicians that go to other clinics or they're part of a group. travel requirements of the position needs to be addressed. And so this is an issue that, again, once we are talking perm and going over the particular job, we'll need to know about these travel requirements. And then you'll see in the next bullet point, layoff of U.S. workers in the same position within 6 months of the application. Also something specifically addressed on the perm application and has to be handled when we're doing the perm in a way that we've apprised these laid off workers of this recruitment process.
These key points you just heard Michelle talking about need to be looked at and considered before you start the recruitment process, before you even get into the meat of the labor certification. So if you're aware of any of these issues, you need to talk to us or your immigration attorney ahead of time.
Exactly.
So that the labor certification process can be planned accordingly.
Exactly. This is all about a key in terms of developing strategy. So, you'll see there, before you start, these are special considerations. So, last but not least, anticipated changes in position or work locations. If you know something is coming, you need to let us know. Something is on the horizon. Don't think that because you've disclosed what's currently happened, it's not necessarily static. So what is PERM? PERM, a lot of people believe, means permanent residency, but that's actually not true. You'll see there that the acronym is Program Electronic Review Management, which is the electronic process that we have to go through when we're doing the PERM process. It's employer specific. And that's a key point that I think some of our clients miss, that this entire process is owned by the employer. PERM can only be done for full-time workers. And you have to conduct recruitment within 180 days of the application. In recruitment, we're not going to spend a lot of time on, but basically you have to show that there's no minimally qualified U.S. workers for the position that you're recruiting for. And one of the major key components, but we haven't seen this be an issue, at least with our physician clients, has been that they must pay the prevailing wage or higher once the foreign worker obtains their permanent residency. So I know you see PERM and permanent residence a lot in here, but keep in mind the PERM process is what has to happen first.
Yes, I always like to make the clarification because PERM is just the method. It's just the program under which you can file petitions with the Department of Labor. But the program actually is the labor certification. So it's still a labor certification application. It is regulated by immigration and is for permanent residency. But the program under which you complete the labor certification process is the PERM, Program Electronic Review Management.
Right, and this is with the Department of Labor. So we're not even with USCIS or with immigration at this point. We are just trying to prove that the labor market cannot supply the employer with the minimally qualified worker they're trying to seek. So what are the 5 methods of recruitment? So we talked about special considerations. What do you have to consider? What do we need to know before we get started? Once we've cleared all those issues, what do we need to do? We need to recruit, and this is where recruitment starts. There's 5 methods of recruitment, and you'll see listed on there. This comes in the form of multiple ways, right? Their ads must identify employer accurately. They must direct responses to the employer. They need to sufficiently describe the job opportunity so that applicants know exactly what they're applying for. You want to avoid anything misleading or something that could be taken out of context.
The perfect example we always kind of give is, if it is a physician, right, and we say it's an internist. Well, everybody knows what internists do, and right there, the title describes the job. So you really don't have to add a lot to the advertisement, because just by the fact that you advertise, we're looking for an internist, the job, the title itself appraises people of the job that is available. As opposed to, for example, we have a lot of IT workers or positions, and if you say we need a software developer, there's thousands of different languages.
We've learned that software developers come in all sorts of shapes.
Exactly. So you need to give a little bit more detail as to what type of software developer you're looking for, so applicants know what the position is about and what they are going to be applying for.
But that's exactly why this is a really good process for physicians if they can, because the ads and everything regarding the job are pretty clear. One thing that is nice is that the wage does not have to be printed on these ads. But that does not mean the employer is not relieved of that obligation. That's exactly what you're signing up for. So there goes recruitment. So employer obligations, we kind of mentioned that briefly, but pay all costs associated with the perm process, including attorney's fees and advertising. The employee cannot be the one who's paying for these. As a matter of fact, those are specific attestations that are now contained in the perm. So this is not just a safe practice, it's actually required by law, and that's something that's important.
And this is important to keep in mind because we know with some employers may not be able to pay all the cost of a labor certification or perm process, and that might become an obstacle to proceed with the labor certification because by law, employees are not allowed to pay these fees, and us as attorneys, we cannot accept the money but from the respective employer.
Exactly. Conduct good faith recruitment efforts without the sponsored employee involvement. Now, this one's a little bit difficult, I think, for the sponsored employees because they want to know what's going on. They want to kind of be kept apprised of how the process is moving along. But we have to gently remind them all the time that because this process belongs to your employer is the one who knows. And we want to avoid muddying any waters or to come off that perhaps there wasn't good faith recruitment if the employee's involved. For example, one nightmare case was where a sponsored employee put down their email, and because it did not have their name, that was the employees, they were getting the recruitment. Well, as soon as that was found out, that was many years ago, I mean, we had to stop everything because how could you say that you were conducting good faith recruitment if the sponsored, interested employee is the one who's doing the screening?
Not only that, but that goes to the point that we addressed at the beginning, why it is important to know if there is a familiar relationship between the sponsor employer and the sponsored employee,
Exactly.
Or whether the employee has some sort of financial interest in the company, like a share or owns part of the company, because it all goes to good faith recruitment. What are the chances that if you are sponsoring your nephew, you're going to accept the petition from somebody else who you don't know to get the position that your nephew could have gotten if the labor certification is approved? So all of that ties together on how to conduct the recruitment.
Precisely. And then we need at the end of the day, the employer should confirm that there was no qualified U.S. workers that responded to the recruitment. That's the only way you can proceed. So how do you document that? You prepare a detailed recruitment report that describes those efforts that were taken. They want everything. They want the number of applicants. They want to know the exact reason for rejection of each applicant to basically prove that, again, you did not have any minimally qualified applicants. Mm-hmm. And I'll mention, in recruitment, in real-world recruitment, there's not an employer that I've met, or that either of us have met, that will say, I want the minimally qualified guy to come and take this job. They want the most qualified. They want the best of the best. But this perm process turns that on its head. It's like a parallel universe. So we want you to understand that, yes, we've said it several times, there's no minimally qualified U.S. workers responding to this recruitment.
Yes. And when it comes to the interviewing or screening applicants and going through the process of who has applied and whether or not is qualified, it is important to remind employers, and we do this every day in our cases, is you need to screen out those petitions as they come.
Exactly.
Don't wait until the end of the recruitment 2 months later to decide if the one who applied 2 months before might or might not qualify. For the Department of, because in real life, if you are recruiting for someone, you're not going to wait. You're going to go through those petitions as soon as possible. So the Department of Labor and even the Department of Immigration, they do expect that employers conduct the recruitment as if they were going to hire someone immediately.
Responsiveness.
And no delays, and good faith attempts to contact people. So, for example, one of the issues that we had, and we are addressing this, and we have done it for years, is many people start the recruitment with looking at the applications or the resumes. They may just do initially a quick phone call. If the individual doesn't reply, they may send a quick email. We've been trying to reach you. And most people stop there because that's the norm, the practice, right?
But in the perm realm,
for the perm, what we advise, and this is something that the Department of Labor has ruled and has even guidelines, in the world of the perm, you need to go a step further. So yes, you cannot reach the person by phone, even if you try 5 times, and you will never get a response on your emails, even if you send 5 emails. We always request, if there is an address, send a certified letter. That you get confirmation that you send the letter to the address on file. At least you try to contact the person, and you have something in real time, plus copies of the emails you probably sent, and you can tell no one replied to it.
And all this is important because you have to maintain all this documentation of recruitment efforts for 5 years from the filing of the labor certification. And everything Angela mentioned is what we advise clients to put in that documentation retention file.
And it goes back to good faith recruitment.
Yes. All right, so let's look at the process overall. This is kind of the timeline that we're looking at. Recruitment before the perm, 3 to 6 months, no more than 108 days, because you have to have done recruitment within the last 108 days before you file. After you filed, DOL current processing times. It says 2 to 4 months. We've been monitoring that. That still is holding fairly true. And I double checked the processing times for perm audited. It was closer to 7 months. Now we're about 8 to 10 months, and that's just where we are. Processing times have slowed down a little bit. But once you do get that perm certification, you have to run on a clock. It expires in 6 months. So we always tell employers and employees, once we get that certification, we need to hit the ground running because that 6 months will expire before you know it. So the I-140 petition, we've gone through perm. What's the next step? Employer must file the I-140 immigrant petition within the 100 days of the perm approval. In this, the employer is basically proving, is going to have to present evidence that they're going to be able to pay that offered wage, the prevailing wage or higher. So this is where the employer has to turn around and show, yes, we can pay this wage, we can proceed. That's evidence that's presented to USCIS. And again, this is where the employer is going to show that the sponsored employee has the qualifications, the education, the experience, the specific skills to meet this. And of course, best practice, we advise to do premium processing. The fee is an additional $1,410, but in 15 days, you'll know whether or not you have an approved I-140.
Yes. Regarding the ability to pay, one thing we always advise clients, or we do even before we start the recruitment. This is one of those things we look at before we start the perm recruitment, is the financial information of the employer, because it really doesn't help anybody to go through a very extensive and time-consuming recruitment process and then get a labor certification approved and come to the point where we're ready to go to the Department of Immigration and find out that the company cannot prove they have the ability to pay the salary that was offered. So we do look and talk about financial issues at front.
Yep.
So that when we get to the second step, we're not going to have any problems. It's just a matter of collecting the documentation and sending the petition out.
Precisely. And there you'll see there's a couple examples of kind of the following of the documents that we include and that traditionally are accepted by USCIS. The other thing that definitely needs to be contained in the I-140 is evidence of the employee's qualifications. Well, for physicians, this is fairly straightforward, but for physicians, they're used to doling out their credentials all the time, so this is just another instance where we have to prove yet again that, yes, the sponsored employee has all the necessary licenses, diplomas, we present transcripts, any training certificates to show that you meet the requirement for example, to be an internist.
Correct.
And if it requires experience, and this is for maybe a little bit higher level positions, if they require additional experience, this is where we detail it through letters of experience from previous employers. Now, when we were talking about laying out strategy in the beginning, these detailed letters of experience from previous employers need to be collected beforehand. We need to know that those are available. So, now that we've discussed all of the PERM process, which the labor certification process for physicians, let's move on to the next option, which is the Physician National Interest Waiver.
Yes, I believe, and we always start with the labor certification and national interest waiver because these are the two options most commonly used by physicians. The national interest waiver petition is a green card immigrant petition. Is different from a J-1 waiver petition. I make this clarification because it's often these two are confused, and sometimes during consultations we do have to explain to clients or J-1 physicians that the J-1 waiver has nothing to do with the national interest waiver. The national interest waiver, as you can see, is two steps: is the I-140 petition, and then the final petition, which is the adjustment of status, or the DS, and Michelle already mentioned about whether if it is in the United States you can do the 485, which is the adjustment, or if you're going to obtain your green card at the consulate, then you do the DS 260 petition. How does this work? So in the national interest waiver, individuals sponsor themselves. There are two types of national interest waivers. The general physician search work is in national interest, or the medical practice. And the physician medical practice is the one that requires a 5-year commitment. The general one is where you have to show to the Department of Immigration that your work is in the national interest. As a researcher, that what you're doing has an impact, and to that there's an extensive documentation and evidence that has to be provided so to demonstrate the national interest of the United States. For the medical practice one, it's 5 years practice. Physicians need to commit to work in an underserved area or with the Veterans Affairs for 5 years. They need to work in an underserved area, which is a HIPSA or mental area or a medical underserved area. One of those is for specialties or primary care. Is for full-time employment, and you do need a recommendation from the Department of State. In the state, you're going to be working the 5 years before you can file the petition with the Department of Immigration. Physicians must file the petition that is the I-140. If you noticed with the labor certification, you start with the PERM and then you move up to the I-140. With the national interest waiver, you start with the I-140 and then you go from there. There's also a 180 days term, which is from the moment you sign the agreement, the 5-year agreement, or you obtain the letter from the Department of Health, you have to file that petition. Similar to you complete the recruitment, you get the labor certification file, and within 180 days you have to file the I-140. The qualifications of the individual, the physician, have to be documented. Again, same as the labor certification. In the I-140, you give copies of all the credentials, licenses, and any other requirement for the specific job. There is no premium processing available for national interest waiver, and this is a mystery.
That's a shame.
It's very selective. There should be, but there's none. So there you go. You have to wait the 8 or 10 months the USCIS takes to process these petitions normally. So the timeline, again, physicians sign the employment agreement. The attorney requests the Department of Health letter. The I-140 is filed, and then the Department of Immigration processes the petition in 8 to 10 months. The beauty of this is that you get to establish the priority date, and we'll talk about priority date, and the day you file the I-140. Even the Department of Immigration takes 10 months to approve it. Difference with the labor certification, because when you do the labor certification, the priority date is established on the day you file the labor certification or PERM, as opposed to the I-140. So we have here a little chart comparing the national interest waiver and the labor certification. So national interest waiver, you self-sponsored yourself, meaning you filed the petition for yourself or by yourself. Yes, you need the employment agreement for 5 years, but it's only to document that you have a commitment to work in the underserved area for the full 5 years. Keep in mind for those physicians who obtain J1 waivers, the 3 years they have to work in the underserved area in compliance with the J1 requirement counts towards the 5 years of the NIW, which is great because I usually tell physicians, if the NIW is the right petition, what I tell them is don't think about the NIW as a 5-year commitment. It's more like 2 additional years because they have already committed to the 3 years. They have to do it. In addition to that, they'll do just 2 more and then they're home free.
Yep.
Free in terms of they'll get the green card at the end of the process, whenever that might be. Labor certification, there is no requirement for working in any specific place or any term of years, but the employer must prove that he attempted to recruit qualified U.S. physicians, and we already talked about the recruitment process, which is completely different from the NIW. In the NIW, you don't do recruitment. There is no minimum salary required for NIWs. That doesn't mean that physicians not going to make money. It's just that under the labor certification, one of the requirements is the employers must obtain a determination from the Department of Labor in terms of the salary to be paid to the individual based on the specific position in the area where the job is located. With the National Interest Waiver, there is no such requirement. Self-employment, National Interest Waiver, you can self-employ yourself. As opposed to the labor certification that is employer specific, you depend on the employer to sponsor your green card or your labor certification in I-140 all the way through the time you get the green card, which means you have to have employment until you get your green card. So keep an eye on that. For the NIW, you can do your own petition, you sponsor yourself. You're supposed to work for 5 years in the underserved area. You can even open your own practice and do a self-employed H-1B, or if you're working under an EAD or employment authorization document, you work the 5 years. It's your own company, and you get the green card through that. After you complete the 5 years, actually, you can sit home because the green card is yours.
Yes.
And nobody's going to take it away. The 5 years contract required versus no contract for the labor certification. So frequently we explain clients because they are always talking. And in the healthcare industry, the norm is to have employment contracts for many, many, many valid reasons, and you want to have an employment contract. But for immigration purposes, specifically for the labor certification process, you do not need an employment contract. The Department of Immigration doesn't care for an employment contract because you will have to abide by the terms of the labor certification and later on the I-140 petition. One more difference, or a couple more differences between the NIW and the labor certification or perm, is that in NIW, the green card may be granted 10 to 12 months after completing the 5 years of service. In many cases, we're not going to talk about physicians from India, China, and a couple other countries because those specific physicians take longer. But normally, once you complete the 5 years, you submit the additional documentation to prove you completed the 5 years, and then the Department of Immigration is taking. We're seeing some applications approve the 485 petitions in less than 10 months, but yeah. I don't know if that is a trend or what we're doing, but for the time being, we're still within the 10 to 12 months.
Right, and you're going to provide, oftentimes we will get an RFE for updated evidence regarding compliance.
Yes, we do. And when we file the 485, if there's an adjustment of status, that's the time where we complete and file the documentation for the 5 years. The LC, you can obtain, we can say that exempt from those nationals from India and China, mainland. We could say that is in about 1.5 to 2 years you could obtain the green card from the day you file the labor certification. except for those physicians who are subject to the J1 waiver 3 years requirements, because even though you can do the I-140, the labor certification, everything related to the green card during those 3 years, don't wait until you complete the 3 years because you waste a lot of time. You cannot file the final petitions until after you complete the 3 years, meaning you couldn't go to the consulate for that interview before you complete the 3 years, or you could not file the 485 before you complete those 3 years. In terms of concurrent filing, you can file the I-485 and I-140 concurrently in both categories. And for the National Interest Waiver, and we do this frequently for some physicians whose spouses might need work authorization, if they are able to file the 485 concurrently with the I-140, they could do it before they complete the 3 years of the J1 requirement, because this is an exception, so that employment authorization can be obtained for spouses to work. Exactly. Physicians have to work in the H-1B all the way until they complete the 3 years, but with the caveat that if at the end of the process, for any reason, physician changed their mind and they had a labor certification and they can get the green card sooner than 5 years, and they decide to go in a different direction and get the green card through the labor certification, then at that point they might need to file a new 485, because the one that is accepted under the National Interest Waiver NIW will not be completed because it was filed before the 3 years were completed. So USCIS has made it clear they do not accept the conversion, and then a new 485 has to be filed.
Okay, so now that we've finished comparing those first two options, a third option that's available is what we call the famous EB1. I think people have heard about it as the Genius Visa, but it is also going to start with an I-140 immigrant petition, and if you can meet all the requirements, you can proceed with the green card application, whether it's inside 485 or outside US 260. So, let's see. What are the basic requirements? Must show sustained national or international claim in the applicant's field of endeavor. And sustained a claim has been a pretty sticky spot for USCIS as of late. Overall evidence must show that the applicant has risen to the top of their field. Now, that is a really interesting phrase, because many folks believe that they've risen to the top of their field, but proving it's a different story. We also must show that there's a prospective contribution to the United States. And how we show that is that the continued work is what's going to be to the benefit of the U.S. The bonus about the I-140 through EB1 is it can be self-sponsored, but you must show that there's prospective employment in the U.S., that you may be a genius, but if there's nothing for you to do here in line with that particular field of endeavor, we're kind of cut off at the knees. We can't proceed.
Yeah. Well, and this is interesting when we talk about sustained, and we had a few consultations. I think there's a spark and consultations for EB1, where, yes, it is obvious, and looking at the resume and some information or documentation, you can see how the person has done lots of work and has done a lot of things that would place her at the type of the field, but only for a few years. Mm-hmm. And when we start looking for sustain, we're looking at today, and we look back, and it has been sustained through the years. It's not just I did all of this for 10 years, but in the last 2 years, because I'm doing something else, I didn't. That will not work. It has to be not only all the way through you file the petition, but also until you get the green card. Mm-hmm. Because if you're extraordinary ability, you're supposed to be extraordinary ability at the time you get the green card, even if it takes 2 more years after you file the initial petition. So sustain means all the time until you get the green card.
Until you get the green card. So one of the additional things that we'll have to show, it's going to be national or internationally recognized prizes or awards. Oftentimes we, say the Nobel Peace Prize, but not everyone's a Nobel Peace Prize receiver. So we're looking at other sorts of awards. Again, these awards should be going back to this field of endeavor. We have several people that have recognized and received very prestigious awards, but it's not necessarily tied to that particular field of endeavor. And so if that's the case, it just doesn't count. So and this is where we just tell folks, pull out your CV, pull out your resume, and let's look at dates. Let's look at where you stand in terms of these awards. Your resume is actually the very first thing we look at, because if it's current and up to date, we can analyze it for the beginning.
Yes, and this is important because it is in the particular field of endeavor. So what we're looking at, and I'm going to just give you a general example, and usually this is what we kind of tell physicians, because honestly, to us, all physicians are extraordinary abilities. We have no doubts about it. But
Yes.
for the Department of Immigration, a physician is a physician. So they're not going to be judging you according to, oh, well, you're a physician, let's look at other physicians. No, they're going to be looking at, okay, you're a physician, great. If you have a specialty, okay, I'm a cardiologist. Okay, so they're going to compare you to other cardiologists, not other physicians, other cardiologists. And if you happen to have a specialty within your cardiologist field, then they're going to be looking at that specific specialty compared to others with the same specialty. So that's how they determine whether or not you rise at the top of the field.
Exactly. You'll also see their published materials. Now, this is physicians, if you are publishing material in major professional media, if you're being featured, and we did have a client several years ago that because of his particular work being groundbreaking, he was featured on multiple non-media, just for kind of this breakthrough. And that's what they mean when they say published materials, about what your work is. So if you did something of a breakthrough in terms of in cardiology, and that's being featured, that is where you meet this requirement. Again, for a lot of physicians, judging the work of others, either individually or a panel, oftentimes you're invited to judge, but you actually don't just present the evidence of being invited to judge. They want to show that you've actually judged. So you've accepted these invitations to judge folks individually or on a panel, and that evidence needs to be presented as well. Let's see, so we'll move on. Original contributions of major significance to the field. Now, this is what Angela was talking about. What have you done specific to your field? So going on the example of the cardiologist, what has a cardiologist done that's original? And this is important because a lot of research builds upon research. So we have to show that your contribution is unique to you, and even though it was you were there because of result of everyone's other research that you were able to get there, we have to show that distinction. Authorship of scholarly articles. This one's actually pretty easy. We definitely go to your Google Scholar profile and try to pull stuff up. So if we can find you a Google Scholar, that's great.
Yeah, but I think it's fairly easy, but also deceiving. Because some people are thinking volume. And what they need to look at, yes, you might have 100 articles, but when you look at substance, it may be that only 5 or 10 really are substantial to the occupation and have been published in magazines that or journals that really attest to the extraordinary ability. And here's where I tell people, other people may have only 5 to 10 articles, but they were published at the journals at the top of the field, and that might be enough. So it's not just volume. Citation is a volume kind of thing. How many times have you been cited? But articles, authorship, and scholarly articles, you're looking at quality rather than quantity.
Right, and then the other important thing to note is, where are you in the line of authors? Like, if you are first or second, great, but if you're more like 5th or 6th, they're not going to give a lot of weight to that.
Exactly.
High salary or compensation as compared to others in the field. That was a little squirrely. If you are at the top, we can show that with evidence about others are being paid in the field. We can purchase surveys. That one's, if you're definitely getting paid top dollar, we definitely highlight that one.
And that is also deceiving, because frequently we do have doctors that are paid top dollars, no question about it. But when you start comparing and looking at how are these payments or these salaries being paid, and a lot of that means, well, there is additional money that I'm getting because I'm doing this additional work. Or these are bonuses based on productivity. Or this is and that's how the salary becomes to be big. What the Department of Immigration is looking at is that you're being paid a base salary and that an entity will pay you almost anything to retain you. That's what they're looking at compared to other individuals.
Performance and leading a critical role for distinguished organizations. This one we could spend a lot of time on, but we'll just mention that if you've been in a leading or critical role, we need to develop and see how that has come to be. And other comparable evidence, this is kind of the throw-all by USCIS. They basically say, if nothing falls under the other previous 8 categories, but you think it's significant enough, present it.
How easy are those cases, Michelle?
They're not. But we have been able to get them through on other comparable evidence. But it's one of those things where you got to come and show us how none of your, nothing on your resume or CV falls under the other 8, and then how can we highlight that? Briefly, outstanding professor researcher. We'll touch on this one. This one's very specific. Again, very much akin to the labor certification. This is owned by the employer. There you see the listed 3 basic requirements. Again, a lot of these things you'll notice that they use the same language, but it's not really necessarily the same thing. A lot of the requirements will seem to overlap, but they're very distinct. International recognition for outstanding achievements in the particular academic field. So we're looking to see what your performance has been in academia and how you're allotted by the international community in this field. Also, it requires at least 3 years experience in teaching or research in that particular field. So if your work in one field led to another, we can't count that. We have to look at what it is you're doing in that specific field when the employer is sponsoring you. And additionally, you have to be entering the United States to pursue a tenure or a tenure track teaching position. We definitely will take a letter from the university that they specifically have to have that language. Or if it's a comparable research position at a university, that has to be well documented, or other institution of higher education. So there's a lot of ors here. So there's a couple of different ways we can look at this, but we're going to be examining the employer when we're looking at whether you can qualify.
Yeah. And this all points out to those physicians who have taken a more academic role, where they're more involved with the institutions of higher education, where they're being more teaching kind of jobs and doing the research than the clinical medical practice physician. So that's a pretty unique pool of people that qualify for that.
Right, and most of the time you're going to be employed by a university.
Yes.
That's conducting you.
Mm-hmm. Mm-hmm.
So, let's see. So you must meet at least 2 of the categories. Again, you're going to see this list come up.
Again.
And again, it looks a lot like EB1. It looks, smells, feels a lot like it, but it's not necessarily it. We're looking at the employer, and you'll see there whether you have received major prizes, your membership in organizations, published material.
But academically.
This all needs to be geared towards your research. So what happens? You file your I-140 with USCIS with all that evidence that we just discussed. Your processing times right now are 8 to 10 months, but of course, beautiful thing, premium processing available for this one, so we can get a decision within 15 days.
Mm-hmm. Mm-hmm.
So we are going to we're running a little short on time, so we're going to speed it up. And so, let's see. All right.
The immigration visa process, so we look at processing options. We already talked about the options I-140 versus labor certification, and you know what that is. Then you have to decide whether it's going to be consular process, DS, or it's going to be I-485 adjustment of status in the United States. You have to be in the United States in legal, lawful status to file a 485. Then the main issue here is going to be the priority date, whether it is current or whether it's not. A quick fact for you to keep in mind is that the J1 physicians must complete the 3 years medical service before they can either consular process or file the 485. So when you're looking at the Adjustment of status. You have to be in the United States. You have to file. You cannot have violations of status more than 180 days. And please, 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 if you have any violations of your status, you check with an immigration attorney immediately, because the 180 days may not even count, depending on the violation. The I-485 is filed. The employment authorization can be obtained as long as with travel document while the petition is being processed. Processing times are 6 months or more. We're seeing longer than 6 months, definitely.
Absolutely.
And depending on the priority date, if there is an issue of priority date, you won't even get to do the 485. But if you get to do the 485 and then you become subject to the priority date, then you have to wait. I just want to get to the priority date. There is information about the DS-260, same process with the Department of State, consular process, but subject to priority dates if needs to. Sometimes people find that consular process, depending on the consular, might be faster.
Yes.
So many times we process the petition saying the individual will not file for adjustment of status but consular process, because it really takes somewhere between 3 to 6 months for people to obtain the green card. And you don't have to be outside the United States. You can just wait until you receive the appointment to go to the consulate for your interview, and then go out, go to the interview, and come back. And it takes somewhere between 3 to 6 months as opposed to 8 months or 10 months.
Right, and this is very important because you're actually coming in with your immigrant visa, so you're coming in as a green card holder.
Exactly. The key here is priority date. What is a priority date?
It is your key to proceed. So the priority date is going to be the date that you initially express your intent to immigrate to the United States. For employment-based petitions, we discussed labor certification. It's going to be the date you file with the DOL. If you went with the I-140, NIW, or the EB-1, it's going to be the date that you filed that petition. The date on your receipt notice is going to establish your priority date. And again, if for some reason you were able to cross over to family-based petition, it's going to be the date that the I-130 was filed. So you have, pay attention to EB-1, EB-2, EB-3, whether it's professional worker, skilled worker. Why? Because we're going to be looking at that in comparison with the visa bulletin.
What you want to keep in mind when you hear these terms, EB1, EB2, EB3, and you're thinking, what are they talking about? The EB1, the EB stands for employment-based. So you know we're talking about something that is being sponsored by an employer. When you hear EB, immediately think employer. Or self-employment.
Yes.
That is related to employment. And then the 1, 2, 3 depends on the category. Extraordinary ability is for one, the top of the field. The second category is for people with advanced degrees. Doctors fall in the EB2. Also, you have the EB3. And sometimes for priority dates, you may want to downgrade your EB2 to EB3.
It sounds counterintuitive.
And that's another conversation. But think about the kind of degrees. The higher the degree, the higher the standard of proof, the closer to one is going to be. And sometimes being one is better than two, but not lately.
I know. Okay. And so here you'll see that there's listed the website for the visa bulletin. And we spend a lot of time at this website. And since it's been a while, but they have introduced, and what you may not be familiar with, are these final action dates and then dates for filing. There's 2 different sets that we have to look at. And you just need to understand where your priority date is and where you're going to be processing your green card to know what to look at and where. Mm-hmm. So, let's see.
When you go into the Department of State visa bulletin, this is what you're going to see when you go into the employment-based priority date.
So you have a snippet here of the visa bulletin from April, and you'll see we've mentioned it briefly. But India is, one of the countries that have been designated that are pretty far behind. But if you look at the worldwide category, you'll see the C there means current. So if you are from any other country other than the one listed, you're under worldwide category. EB1, they're looking at January 18, and this just goes to your point. Sometimes EB2 is better than EB1, because in this case, the EB2 is current. But if you had an EB1 extraordinary ability approved I-140, you're still and it was after January 1st, 2018, you're still waiting.
Yeah, and there's no way you can downgrade an EB1.
No, you can't.
You're EB1, you're EB1. However, if you do a labor certification, for example, and I had a few clients that if you see here, the priority date for China, where is it? No, no, I was going to go with the EB3. If you see here, for example, the priority, oh no, it changed for April. We purposely put here the information for April because the priority dates are released on a monthly basis by the Department of State with a month in advance. So, for example, we get the priority days that starts on April 1st for the entire month. Usually, we just got them the second week, last week.
Yes, last week.
It usually comes out between the 10 and the 15, 16 of the month. So you know what is coming up the next month, and you can start preparing that petition if you know your priority day is going to be up.
And like many immigration attorneys and clients, we're constantly checking to see when it's updated because we want to know if we can go ahead and file.
Correct.
So tips for fastest processing, first of all, you need to determine whether you can file your 485 or DS-260. Sometimes, like Angela said, going through the immigrant visa process abroad through the consulate is going to be faster than staying inland and filing the 485, especially with this crazy backlog that we've seen with 485 processing.
Yeah.
Number one thing, as soon as you can file your I-140 though. Why? Because a lot of times, unless you're doing labor certification, that's what's establishing your priority date. So as soon as possible.
And even with your labor certification, you want to start it as soon as possible. This goes to physicians and J1 waivers that have to meet the 3 years. Don't wait until your 3 years are up to start these processes. You can start as early as the first date of employment because the petitions can sit there until you complete the 3 years and you're able to just file the final paperwork to get that green card.
And we're going to say this, just use premium processing anytime. It is $1,410, but within 15 days, we know that we're on sure footing. So if it's available for that particular petition that you're going through, please utilize it, especially if you're consular processing, because that's going to move that right along to the embassy and getting your appointment date over to the consulate. And also keep track of cutoff dates against your priority date. One thing we hate to hear about is visa retrogression, but if you know where your priority date is and we file when we can, even if it retrogresses, we are keeping tabs on that priority date. And let's see. Other options, just in passing, so that you know they're out there. If you have an immediate relative, they can file for you, U.S. citizen spouse or U.S. citizen child over 21. A lot of clients will switch over to a family-based petition if they can. Asylum, a lot of requirements here. You're just looking at the protected groups. You definitely got to talk to us if you want to proceed asylum because there are time restrictions for filing. Basically, a year from when you landed here. We need to look at the country conditions.
The perfect example there, we are seeing a surge
on
asylums for individuals from Venezuela.
Yes.
I know that's a good, is a tool if you meet the requirements, but keep in mind that if you're not within these groups, race, religion, nationality, membership, or political opinion, if you're not persecuted on any of these grounds in your home country, not just because your home country is going through these difficult times, means you qualify for an asylum. So keep an eye on whether or not you meet those requirements because we have seen a lot of people just filing for asylum hearings. And asylum hearings are taking 3 to 4 years to go before a judge.
Yes, they are.
And many of the asylum petitions, and I was looking at a statistic the other day, they were saying that about 70% of asylum claims are denied.
Yes, so what happens with an asylum claim, you file an affirmative asylum application if you can, within a year of getting here or within a year of changed country conditions. If it's not approved by the asylum officer, it gets referred to immigration court, where basically removal proceedings will be initiated, and you can present that application again. Lottery, the diversity visa, that's in flux right now. We don't know how long we're going to have it, but the fact is, if it's an option, it's one you can consider.
And only the countries that are up for that.
Okay, so now we're going to switch to the Q&A. I know that we're almost wrapping up, but please, for confidentiality purposes, we ask that you do not say your name, and please remember to speak clearly and loudly in case others can benefit from.
Do we have any questions? No. Anybody online that want to ask any questions? Okay. Well, I have a couple questions that came up.
We got
via
some
email.
Okay.
And one of them is, can I apply for more than one immigration petition if I qualify for 2 or 3, or I'm limited to only one?
Well, the answer is you're not. The way I explain it to clients is, if you have, another track that you could possibly utilize, you want to go ahead and try, because that one may get you quicker than, the process that you initially. You do not have to commit to one singular process, but you want to make sure that if you are doing multiple processes, that everything is in line and there's a cohesive narrative and nothing is contradicting.
Correct. It's about consistency. So, for example, I can tell you we had clients who we initially, many years ago, clients from India, we did the labor certification because the employer wanted to sponsor them. They got that. And through the years, they had become at the top of their field. So we later on helped them out with an EB-1, and they finally got their green cards based on the EB-1 rather than the EB-2 that they initially started the process with. Or we also had physicians who they start with the labor certifications or the EB-2, and then they get married, U.S. citizen, and the wife comes in, or husband, and they petitioned the physician so they can get the green card based on that rather than the other. It's about consistency, making sure everything is lined up, and that if you, in one petition you said you're a doctor, the next one you're going to say the same thing.
Exactly.
Yeah.
Or simple things in terms of just credentials and where you've been working,
Employment history.
there.
We see that a lot.
Yes.
And what we do is we usually, more than one in our office, kind of looks at these petitions to make sure that the dates in the same petition, in the first petition, are the same like the dates in the second petition, because you want consistency. So when we take cases after a physician has worked with somebody else, one of the first things we ask for is copies of the previous petitions for consistency purposes. There's another question here about employment authorization. Can I work on my employment authorization and an H-1B visa at the same time?
We encourage clients, if you're doing your J-1 with your H-1B, you have to be an H-1B. We have had some instances where a client did not want to go for the H-1B visa stamp, so because he had the EAD and advanced parole, would enter on the advanced parole, but we had to immediately turn them over and file a change of status from parolee back to H-1B. Because
well, actually, it's a re-adjudication.
Re-adjudication,
because
correct.
you can't just change the status unless you have non-immigrant status.
Exactly. So it's one of those things where that has to be carefully monitored, and you definitely talk to your attorney before you leave the country.
Yes. Well, I think this is it. We don't see any more questions. We thank you very, very much for your time. We just want to remind you,
our next webinar, please save the date, April 17th, Understanding J-1 Waivers. So if you're a physician and you were attended today, and you have a couple questions, or can pass this along to any of your fellow physicians that are going through the J-1 waiver process or want to look into it.
Or they will be going through
Right.
the J-1 waiver process later on in the summer to start filing petitions in the fall.
Right,
So
and
you don't wanna
April
miss this.
April 1 is, or April 17th is one you're not going to want to miss.
Yes.
Thank you for your time.
We'll send you copies of the presentation, the recording, and a questionnaire. Please give us your feedback. Let us know how we're doing and how we can improve. We appreciate your time, and we'll see you next time.
Take care. Bye-bye.
Thank you.